We want to avoid pretty much at all costs any scenario where the lawyer could end up as a witness. That's kind of like an automatic red flag for that should trigger a red flag for anybody saying that this should be almost an automatic disqualification. And that would come up, for example, where the lawyer was involved in the negotiations involved in coming to that agreement, or possibly in the initial drafting of any agreement. And even though there's, if it's a well-drafted agreement, it's going to be hard to conjure up a scenario where parole evidence is really going to be relevant. Nevertheless, there are circumstances where course of conduct diverged. I know this never happens with anyone that Russell represents, where course of conduct by the clients diverges from what's actually in the written agreement. But at the outset, it's certainly a good idea, a good practice to inform, not only to inform all the parties. If you're there, sometimes it's the parties don't really have a lot of money. They really just want to get a deal down, reduced to paper. So you tell everybody up front and reduce it to writing, saying, hey, look, I'm doing this kind of for both sides, and you're acknowledging that even though it might be somewhat of a conflict, nevertheless, it's okay with everybody because we're all really on the same page.